So, Phil, the first one I want to talk about today is a case coming out of the Eighth Circuit Court of Appeals, and I covered this case a couple months ago, saying there was argument at the court on this particular case, and they decided Wednesday to review its own decision. The full Eighth Circuit decided to review the decision of a panel of the Eighth Circuit affirming a win for a company against a coworker who claimed he was wrongfully fired after testing positive for THC. This case comes out of Arkansas. The employee was fired after a routine drug screening came back positive for THC. He argued the termination was unjust because his THC level was below the threshold mentioned in the company's employee manual. He also claimed that the test was picking up his use of oil, which he took to alleviate his back pain. Filed a lawsuit challenging his firing, and the federal district court granted summary judgment in the company's favor, and the Eighth Circuit upheld that, and then the Eighth Circuit decided that it's not going to review its own decision there. The court basically said that employee is an at-will employee, which allows the employer to fire an employee for good cause, no cause, or even a morally wrong cause, and that this individual had THC in his system, and you're not allowed to be quote unquote under the influence of THC in the workplace, and the company was able to fire him.
Bert, I heard you just say a whole lot of things that we could talk for 30 minutes on, but I
Sure.
want to go back to employment at will, good cause, no cause, or
even a morally wrong cause.
Is that going to, are those three statements going to come back someday in a court ruling and say, well, we don't have to have cause, good cause, bad cause, morally wrong cause, so we're just going to fire you? Or is it going to be stuck to THC, you think?
Yeah, no, I think that this standard of at will is enshrined in the American workplace. There's only a few states that don't follow the employee at will doctrine. Almost every state follows the employee at will doctrine, and this is the standard that's there. I would add, in addition to what the court said, where it says you can terminate an employee for good cause, no cause, or even a morally wrong cause, I would say it maybe a little bit differently. You can terminate an employee for any reason, so long as it's not an illegal reason.
There you go.
And so
yeah. I just want to clear that up in case someone misunderstands that. We do have a lot of young listeners that haven't been a part of learning these lessons just yet.
Yeah. So you can't terminate somebody because of their protected statuses. You can't terminate somebody who's engaged in whistleblowing, somebody who's filed for workers' compensation because they filed for workers' compensation. So again, you can terminate an employee for any reason, for good cause, no cause, so long as it's not an illegal reason.
Illegal cause. Very good. So in short, what they've said is, yes, if you have THC in your system, you have a policy for no THC in your system as part of your drug testing policy. Follow your policy and you should be okay.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.